Hello, hello, hello. Good evening. It is Thursday, meaning that we are live. My name is Daphnee Antoine, and this is the Daphnee and Daphnee Show.
My name is Daphnee Camilien. Good evening.
Good evening, everyone. Welcome. So, thank you for being with us. Please come in the room. We have a great conversation for you. So, this conversation is for anyone, whether you are an entrepreneur or a family person or just have a 9 to 5. As long as you're breathing, you need this conversation. But before we get started, Attorney Camilien is going to share a disclosure with you all.
Sure. As Daphnee said, my name is Daphnee. I'm an attorney. Anything that I state this evening does not enter us into an attorney-client relationship. Daphnee Antoine is a financial entrepreneur. Anything she says does not enter you or her into any type of fiduciary relationship. And our guest, who is also this evening, our guest, Grace Okorie-Eric, is an attorney, and anything that she shares does not enter her into any type of any type of attorney-client relationship. All information that is shared this evening is for entertainment purposes only. Back to you.
Awesome. Thank you, as always, for sharing that. With that being said, if you've been following us for the past 2 to 3 weeks, you know that the Daphnee and Daphnee Show is back. We had an amazing show, I believe 2 weeks ago, with Mika Gills, who shared with us how to go ahead and grow a real estate portfolio and scale. And so I encourage you to go back and watch this live if you are interested in launching or investing in real estate. And the last week, we had Laurie Joseph, who shared with us kind of like the 5 pillars, no, the 5 pitfalls, I'm sorry, of when buying a home. So basically, what you should not do, what you should definitely avoid to do when you want to buy a house. So if you're in the market to become a homeowner, definitely go and watch this live. It is so instrumental to help you save money and save headache. And this evening, we have another great show with you. For you, I apologize. And it is the importance of opening a trust. So, that being said, I'm going to have Attorney Camilien introduce our guest.
Sure. So this evening, our guest is Attorney Grace Okorie-Eric. She will be talking to us about trust and the importance of trust, just as Daphnee had said. Grace has a background in real estate. She has a background in immigration, and she has a background in personal injury. So she is a great person to talk to about trust and just information about the benefits of having a trust, and maybe we can talk also about wills and the wills versus trust. So without further ado, I'm introducing you to Miss Attorney Grace.
Hello.
Hello. Good evening.
Good evening. Good evening.
Good evening, ladies. Thank you so much for having me. Thank you, Daphnee and Daphnee. Appreciate you both. And it's a pleasure and definitely an honor to be here today. So thank you.
Well, thank you for being here. And at this time, we're going to have you introduce yourself to the audience.
Okay, so as Daphnee has stated, my name is Attorney Grace Okorie-Eric. I am a real estate and immigration attorney. Well, I'm a lawyer. I've been practicing for about 13 years now. Real estate, immigration, estate planning, personal injury in different areas. But my main passion is really real estate and immigration, and of course, estate planning, as we are speaking on today. I had a conversation with Daphnee, and we were just talking about how so many people don't know about these tools, estate planning, and how these issues come up in our practice in immigration and on the real estate end, about how this simple tool or things that people could have used to just save themselves, save their family, save their whole future, so much stress and so much money. And that was how this came about today. I'm happy to be here and I look forward to sharing as much information as I can.
Sure. So I wanted to start off. Probably we'll ask questions, and anybody out in the audience can write us and ask questions for Attorney Grace to answer. But part of the reason why we talked this why this is such an important topic is I do work a lot with the public and a lot in the legal aid realm as well. And a common, I can't just stress to you, issue that happens all the time is people will contact us and will say, you know, because a lot of people don't, they don't come from money, they don't have money. The biggest thing that wealth that they have is their home or the family home. And so their mom, so let's say it's a person in their 30s, mom dies or dad dies, and they have this property, and the property's in mom and dad's name, and now they want to, take over the property, and what should they do? So I can throw that to you, Grace, and then also or I'll tell you, well, let me say what they should do is they have to go to probate court. Okay. So they, if it's not in the trust, they have to go to probate court, and it's a lot of money. And I'll tell you right now, it's not something, at least in Illinois, we are in the Chicagoland area, and probate judges do not let people do pro se, which is represent themselves. They force you to hire a lawyer. So if you don't have money for a lawyer and you have this home, what are you going to do? And another big issue is sometimes people are saying, okay, I'm proactive. Like, let's say their mom, mom dies, and there's a mortgage on their house. They call the mortgage company and they say, mom died, I'm going to go ahead and take over the mortgage. And then the mortgage company says, wait, really? Oh, we thank you for letting us know. We are now going to put the house in foreclosure because you can't take it over, right? It's you didn't go to probate court. You didn't do the proper channels to say that you are now the heir to the home. And so who owns this house and what's going on? So you try to pay the mortgage and they won't let you pay. They literally will put it in foreclosure, which then becomes a whole mess. So I see this all the time. And there's a simple way to fix this and avoid this. And so that's what I want Grace to talk about.
Okay, that was a lot.
sorry.
No. I mean, there's so many, so many issues there, and you are right. There are little things where there's so many ways to fix it. So many things we can do. What is that? What is that adage? A stitch in time saves nine. Just one little thing you can do. So one of the things I do. Okay, let's rewind back. We're talking estate planning. We're talking, all of this. Start with number one. What is your estate? Estate is all of your all of your assets that you own. So right now is, okay, my bank account, I own my, my clothes that I own, just everything that you own is what is considered estate, your estate. Well, minus your debt, because you can't pass that. But so basically that's your estate. Now, the next step is the estate planning. Estate planning is now, how are you putting these things in order so that while you're alive or even after your death, things are passed on the way you want them to. They are transferred through your family. And, your family is not going through not only mourning you, but also now going through all of this financial issues and crisis. And in most cases, like what you said, Daphnee, it's true. A lot of times people will say, I have the money to pay off the mortgage, and it doesn't make any sense whatsoever. But some of these mortgage companies would be like, no, we'd rather go through the foreclosure process to handle this issue. So that being said, estate planning we're just talking about handling your business and handling your bank accounts, your properties, your, real estate is the main thing right now. So real estate, number one, we had that conversation about the will and the trust and how it protects the real estate. Is it okay if I talk about that? I know.
Yes, please go ahead.
So we talked Okay, hold on. There's this window here that I need to get rid of. This. So the real estate is another. It's one like a different entity itself, a property that has to be dealt with different from how you will deal with your bank accounts, different from how you will deal with your personal property and things like that. So one of the things, and the estate planning is not that you don't have to have this whole convoluted process or whatever. But in our for our situation, and honestly, most people in our most of us and minorities, especially, unfortunately, immigrants also as well, making sure that your real estate is structured in a way that if anything happens to you, it can automatically be transitioned to somebody else, without somebody that you wanted to go to, without having to go to court. Now, for example, one of the things that I do when I do, like the real estate transactions, and I have clients who are buying homes, I ask them this question. Hey, let's say, for example, if it's a husband and a wife, we're like, okay, we want to hold it joint tenants in the entirety, but we want to hold it, the title in it, because it has to be worded in a certain way and held in a certain way, so that if, for example, you have the property and a deed is between two people and is held in as joint tenants with right of survivorship, what that means is that if one of those people passes, that whole property automatically belongs to the other person. They don't have to file anything. They don't have to, they don't need anybody's permission. It's just a legal transfer that happens automatically at death. And then also, so that being property. Now, going down, another thing we can do, the property is a trust. Now, the trust is one of the best tools to manage your estate, especially when it has to do with a property, because it's like it's taking the deed outside of your name, outside of you, and putting it into this trust, which is a separate entity. Now you get to create that trust and get to create the rules of how the money in the trust, who's the beneficiary, who's the executor would be. For example, I have a case right now, actually a closing, that we have a closing tomorrow. This was a lady who had she had no children. She created a trust and put the property, and that's another thing too we also have to talk about, because people are like, oh well, I have a trust, and I have the property. No, you actually have to create the trust, and then now you prepare a quick claim deed, a deed, transfer the property into the trust for it to be valid. Because if you just create the trust and the property is never transferred into the trust, then that's where you have issues, and then so in this case that we're closing, the lady had a trust, set up the trust saying, okay, I'm the beneficiary of the trust. I am the executive of the trust, which means I own this property, but it's in this trust. But guess what? I'm the executor. So I get to say, okay, if I can, transfer the property, what I want to do, with the property while I'm alive. If I'm not around, or sometimes you could say, okay, if I'm not around, or if I'm if I'm sick, um, somebody else, this is who I'm going to name as my successor trustee. And you can, go down the list where you say, okay, I want to do Daphnee as my successor trustee. And then if she's not around, then I'll do Daphnee too. I'll use both of you as my next successor, and just go down the line. So in this case, essentially it was, she passed away now, the property is in the trust, and now the family doesn't have to go through probate, because probate is a whole process where now you have to go to court, and you're essentially going to court to get the court to give you permission to sell this property, because legally you do not have legal authority to sell the property, because you are not named as the owner, you are not nowhere in the chain of title of the property. But as a trust, am I breaking out? I'm sorry.
No, you good.
I feel like I'm breaking out. But as a trust, it's a different entity. So that trust is managing what is happening, with the property. So in this case, the lady passed away. In her trust, she says, if something happened to me, I want John to be um my what's it called?
Executor?
Successor trustee.
The next in line for the successor.
Okay.
I just said the word. I can't. It's been a long day. Sorry. So I want John to manage my trust. And so now, successor trustee. Sorry.
Yeah.
So now she's passed, and John is like, "Hey, she left this house. We want to sell the house. Guess what? Now we're gonna be like, okay, we pull the title. Well, the property, you're not. Who are you, John? We're like, okay, well, this property is in this trust. Now we're like, okay, let's see the trust. Now we look in the trust. The trust says, okay, Anime's trust, blah, blah, blah. All right, well, John, you're not an Anime. But then the trust goes on and say, well, if something happens to me, then John has legal, right as the successor to do whatever, to sell this house. And that is what gives John that right to say, okay, he can sign the paperwork on behalf of the trust and actually sell the house and divide proceeds or do whatever needs to be done with the property. So the trust is a good tool for estate planning, especially when it comes to properties, and also having joint ownership on the property, like the joint tenants, with the right of survivorship. That's also a good way to make sure that if something happens, you can avoid probates, which, like you said, it's very expensive, very time consuming, and honestly, it breaks up a lot of families, because a lot of families are getting along fine, but when they have to go
Mhm.
to court, that's when all the drama comes through and people just turn to everything, something else, just fighting over properties and fighting over things and all of that.
Sure. Yeah, and we had a question. So I would let Daphnee. I don't know if you saw the
Let me do
question.
a quick. I see it. Let me just do a quick. Welcome back.
Okay.
We do have a few new people in the audience. Hello. This is the Daphnee show. I am Daphnee Antoine, and we are with Attorney Daphnee Camilien and our guest this evening, Attorney Grace Okorie. And we are speaking about the importance of opening a trust. So thank you to all of you who are joining us. Wozie says hi. Hey, Wozie, appreciate you. Before I go to the question, let me see. Wanika said, "This is great information. Awesome." Um, and Renee Thomas says, "Well said." And also, if you want me to see your name, you do have to give StreamYard permission to show your name. And then it's gonna, if you don't give permission, it's gonna show Facebook user. So it said need contact information. So I actually have attorneys Okorie a website address. Scrolling down, if you can see it, it says ericlawgroup.com. You'll be able to reach out to her there and scheduling consultation. So for our question, do we want to continue the conversation and the question at the end, or do you want to take question right now?
Well, the question is, I would take the question because it's
Yeah.
relevant to the next topic I
Awesome.
want to talk about, which is about the will versus a trust. Yeah.
Okay, awesome. So I have Renee Thomas. Hey, Renee, thank you for joining us. So his question is, should I put my home on a trust or a will for my son?
Definitely a trust. Definitely a trust. A will does not protect your property. If it's a house, you definitely have to do a trust, because the will is just how it, the will is just outlining what you want. Okay, this is how I want. This is who I want to get this. This is whatever. However, with a will, it still has to be probated. If there's a property involved, you have to go through probate, and then go through whatever state. And just so you guys know too, the probate is a state law. So each state is different. You have to go through your local court, and it has to be the state in where the property is in. So you go through probate with the will, and the property does not automatically transfer to your son. It's just saying, okay, these are what my wishes are. And the thing with the will, of course, like we said, is still expensive because you still have to go through the probate process. Unlike a trust, the trust actually is automatically put in this property into your son's name, as you outline in the trust. So just simple, yes, go with the trust, not the will, for your property.
So that doesn't. So it. Yeah, for your property. If you have other stuff, bank accounts. I mean, you can put money in the trust, but like, I mean, like, if you have you can still do a will, but anybody who's dealing with property, just as Grace said, 100%, it has to go in the trust.
Yeah.
It just if you want, if it's the whole purpose is for a loved one to get it, to be able to take care of, whatever they need to take care of, versus regarding the house, any property has to go in the trust. Like,
Has to go.
right.
Yeah, so you can actually create the living trust, and
Right.
then you deed the property into the trust, or in Illinois here we can create the land trust, which is just to hold real property houses. And even, like, just going back a little bit, estate plans are different for each person. So it kind of depends on what kind of assets you have, how much you have, what your net worth is, how many properties you have, and things like that. But generally, if you want to talk about, okay, what is I want to, hey, this is me, I want to just get my house in order. What are the things that I need? I would say number one, you need the revocable living trust. Now, your revocable living trust, this is your trust that you set up saying, hey, and it's usually, the trust of Grace Okorie-Eric, dated September, blah, 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 blah. Sometimes it would have a number, but that's usually the naming format here in Illinois. You set up this trust now. So this trust is now saying, these are all my things. And even in the trust, you can talk about your personal items. My fur coat, I wanted to go to this person. My this, I want to go to this person. So basically, your trust, that revocable trust, can actually be your will in a way, because it can have all of the stuff that you would have in your will also addressed in your trust. Now, usually what I would advise clients is you have that revocable trust, you put that, and then now if you have any properties, you now quick claim those properties and deed them into the trust, right? If you have a bank account, usually, sometimes you would put the bank account in the trustee's name, or sometimes with bank accounts, you can actually designate a beneficiary with the,
Right.
in your account. So we list the accounts you have and say, okay, we can go to, my Chase account. I fill out the paperwork with Chase, letting them know if anything happens to me, all my accounts just automatically goes to this person. And that's what we call like a transfer on death. Or sometimes you can make it a joint where you are both holding it in joint tenancy. You can also hold an account as joint tenants. So, which means that if Daphnee and I were, holding accounts in joint tenants, and something happened to one of us, the other person automatically can just assume the account without having to fill out any paperwork or whatever. And if you want to close the account, all you have to do is just, the bank will ask for a death certificate, maybe have you fill some affidavit or whatnot. So the trust is really the main thing. Now, even with the trust, as part of that whole estate estate plan, is you have that trust, and then the second thing now is you have the will. Now, what the will really is should be is really just to say that, hey, everything that I have that is not in the trust, I want it to go into the trust. And so that's where we have that pour over will, where it's like, okay, you know what, now, and another thing too, I have to point out with estate planning is, it's always good to update the information. For example, if you had one property in the trust, you buy another property, you want to make sure that that property was properly transferred into that trust. Something happens, you want to make sure that it was properly moved into that trust, so that when anything happens, there is no question that that property belonged to that trust and should automatically be administered the way it's outlined in the trust. So that's the trust, and the trust really can do everything that the will does. And you can just have the will to just have be like a pour of a will, saying that anything you don't have in the trust should be sent back into the trust. And then the next one, most important also, is always that, the power of attorney. You want to have a financial power of attorney, and you want to have the healthcare power of attorney. Financial power of attorney is usually for, when someone is incapacitated, like you're sick or in the hospital or whatever, or you need to. I've had um, I've had cases where, the client was sick and they wanted to sign some documents or whatever, but they were not physically able to. If they have that financial power of attorney, they can have whoever is named on there to just, execute those documents on their behalf. And then also the next document, which is also important to have, is the healthcare power of attorney. And this is important for, those of us with like older parents, and even just, everyone needs one. And that's all just saying, hey, If something happens to me and I'm in a state where I'm not able to make decisions on my own, I would like this person to make decisions for me. And part of it also, you talk about who has access to your medical records, and how you want your end of life to be, and things like that. Those all can be addressed in that healthcare power of attorney. I know that was a lot, but yeah, that's the whole.
No, I mean that's great because it's holistic. It's not just just the trust. It's some people might not, who are listening might not have property now, but they will in the future. But they can go ahead and do a financial power of attorney, or even a health both, right? Because it
Yeah.
doesn't matter about age. Anything can happen to us at any time. So just having those things in place is important.
Yeah.
Awesome. You you said a lot. You gave a lot of great information. I'm following because I was in the banking industry, and then so I've dealt with a lot of what you just explained right now on the banking side. And then so you talked about revocable trust, and I'm sure there's also irrevocable trust, and which I need you to clarify. And also, one of our audience member has a question about that. Uh, Okay, and then because you talk about it, I'm just gonna go to that question first, and then Wanika, I do see your question. I'll go to it later on, and then so I believe this is Mika. Mika was our guest 2 weeks ago. She said, "Can you talk about the difference between a revocable trust and an irrevocable trust?"
It's really in the name.
Yeah.
Revocable means you can make changes. I can change it and decide, okay, I don't want to change this. I want to do this. Irrevocable is just, it is what it is, and it stays like that. I'm not a fan of irrevocable trust. I mean, I know there are certain situations that require that or sometimes demand that. However, um, I don't. I wouldn't say I've ever done that for someone, an irrevocable trust.
And then does the revocable trust automatically becomes irrevocable once the person passes away?
Yeah, I mean, I guess because technically you're not
You guys
changing the
changing it.
trust. Yeah. So,
Yeah.
and that's why I say I've never
Yeah.
done an irrevocable one, because irrevocable means you have the option to, you don't have to change it. It could just be what it is. Now, when the person passes away, and now it's just, okay, this is what the, trustee has to do. And
Yes.
sometimes it can actually give the trustee power to make changes to the trust as well. So not
Okay.
necessarily, it doesn't freeze at the time of death, because it depends on what powers is given the trustee and how long the trust is for. Because sometimes there are trusts that last generations and generations and generations as well, too.
Awesome. I hope this answered your question, Marie Mika. Appreciate you engaging and participating. And so we had Wanika. Okay, here's Wanika's question. Wanika said, "Is it best to set up a trust under a non-profit's name?"
Not necessarily. I mean, it depends. And, like I said, it all kind of depends on what you're trying to accomplish. So if it's a non-for-profit, are you trying to put the property in a non-for-profit? Because a trust is, I mean, not necessarily. And also another thing too, I would say the caveat to, a lot of time these also work with like tax accounting considerations. So if there's like some financial stuff there, or stuff that you need to, then you might want to talk to the accountant to see what's the best way to do that. But generally, you can set up different trusts. You don't have to have one trust. So you can have one trust for this, one trust for that, one trust for the, not-for-profit. Because if you do set up a not-for-profit trust, then I'm assuming you would have to follow the guidelines and all the different requirements for a non-for-profit, which really is not, or I don't think it is beneficial for like the everyday person.
I had
Um,
a, I was gonna
go,
say,
go,
I had a
go ahead.
question. What would you say is the cost of um trust for the? Is it super costly? Is it I don't know. I'll let you expound on it. But what would you, a rough estimate? Not you know
I'll
in
give
general.
you a legal response. It depends.
Yes.
So, I mean, I think that, and I've seen a lot of, their website will do your trust is, automated, blah, blah, all of that stuff. So it can be cheap, but my concern about, doing the trust with these online platforms sometimes is you want to make sure that they're tailored to your states, and they're also tailored to, what you need them for. For example, Illinois, if you have, like, for example, a will, talking about your estate planning, it has like specific requirements of what you have to have there, witnesses, the age and beneficiary state of mind, those kind of things. And those have to be met for the document to be valid. So the thing basically is not just that you're creating the document, you also want to make sure this document, when it's time for me to use it, it passes the legal test, which means that, it checks all the boxes of what needs to be done. Okay, so that being said, I think the trust, and like I said, everybody's different. So everybody, sometimes I have people who are like, okay, I just need a power of attorney, mom is sick or someone, and we just want to get this together to just make sure, hey, we can make decisions for them. I just need a what's it called? I just need to put one property in a trust, and I don't want to create a whole live-in trust, revocable trust. I want to actually just do a land trust and set it in it. So I would say a trust, you're looking like, well, and there are different types of trust, different levels of it and things like that. So a land trust, you would set that up, you pay the, setup fee. And with the land trust, sometimes if we set it up with the title company, there's the annual fees you have to pay. You can set up a land trust, quick claim of property into the land trust for like $500-$600 if it's just that. If you want to do like a whole estate planning, put your trust together, make sure everything, your bank account, all of your affairs are together. It's, I would say, just safely like maybe 1,500, 1,000, 1,500, just to kind of build up to. But however, it's still worth it. It's still worth it because if you don't do those things, like you said, you have to go through probate. And going through probate means that you will pay an attorney a retainer, and you're talking retainers at least $3,000 just to start, and it's going to be billable based on the work. And now, if you have people fighting and filing motions and things like that, that's going to be more time. Like example, I have a client who was going to father owned a property here. She lives in a different state. He had a will. Because the property was not in trust, you have to now go to the court.
Right.
Say, hey, give me permission to sell this property. And now the problem is, there he had property here, has property there. So now you have to go through probate in one state, now have to go through probate in another state. And the crazy thing, the probate in this state turned out to be a whole like it went left. There was drama. There was another will, probated. Like we're like, okay, which one is the real one? Which one is that? So it just could get complicated, and things like this rack up your attorney's fees and the time you have to spend in court and what you have to show, what you have to prove. And then also with the will, because it has to be filed with the court, all of your business is out there because it's public record. So now, everything, a trust is very private where it doesn't have to go through the court. Nobody needs to know the detail of it. Nobody knows your business. Like, okay, I want to, my collection of doll heads or whatever, give to whoever. Nobody needs to know. But in a will, it has to be filed in the court. And something being filed in court means it's public record. If someone just goes in the court and put in your name or, whoever. Yes, somebody just said probate is the worst. It could be, it really is. Because now you have to ask permission from the court to do anything. You have to do accounting. And then when people are fighting, it's a hot mess. It's stressful. Just, I think for the cost of the trust, just, it's so worth it.
You see, I wasn't, with law, I focus mainly on immigration, but for the fact that I do a little bit of work in different areas in some of my legal aid work that I do on the side, and I had no idea for the cost. So I had no idea that's not that bad at all. And even if you had said to me, even if you had said like $3,000-$4,000, to me, I think it's it's a lot of money, but it's when I look at stuff, I'm like, okay, if I drive Uber for how long? I'm just thinking about general. People drove Uber or did a side job. How long would it take them to raise the money? And so when that's very reasonable, and the reason why I say that is it's a real thing. People are losing properties. Can you imagine?
Generational wealth.
I mean, just you're right, generational wealth. They're losing properties. $30,000 mortgage, 40,000,
Yep.
50,000. Right? You know how expensive housing is now? Think about like for the cost of 2 rent payments, you could avoid all of this. And oh my gosh. I mean, I see it all
No,
the
you're
time.
you're right. You're right. And there are people who are preying on this ignorance that,
Yeah.
they're not. So grandma already paid off the house, only has $30,000 mortgage left. Now you're not able to keep it and keep the equity because, oh, it's not in her name. So now we're going to take it to probate and then go through all the creditors. And by the time you talk about the fees and the attorney's fees, blah, blah,
Yep.
blah, all the money is gone. You're like, wait, what happened to that was our family wealth and all that. So
Mm-hmm.
even with the cost of a trust, people don't have to, you don't have to do it all like, okay, I think the most important number one, if you have a property, it's number one. Like you gotta do it. You gotta do it. And there are ways around it where they do the affidavit of heirship or whatever, but that won't always work because you also have to know the heirs. Like for example, sometimes if we want to do a transfer with affidavit of heirship, it has to be after 2 years that the person has passed for you not to even have any issues with the title company. Otherwise, they want you to put down a bond, which is about 10% the value of the property and all that. So at the end of the day,
Wow.
you still spend so much money. And then God forbid you do the affidavit of heirship. What it does is automatically attaches, if there's any lien on one of the heirs, it's like automatically attaches to the property that if you sell it, you can't take anything until that lien is addressed, especially like an IRS lien. And trust me, yeah, I've seen that. But yeah, so the cost of it is very, very, very nominal. Because even the 3,500 is really to do like the whole estate planning. You can actually do it in stages. And I think with the property, it's very easy for like less than $1,000 with a property. You can quick claim it into either a land trust or create the trust, or just if it's elderly parent and a child, you can do a quick claim and just hold it in joint tenancy with the parents. That's a quick way to solve that, because the only thing is, you never know who's gonna go first. We think the older person is gonna go first, but and that way, if I had a mother and son who purchased a property. They own the property in joint tenancy with the right of survivorship. That way he knows that, okay, if anything happens to my mom, she gets older and she goes on, this house automatically becomes mine. I'm on the title, I'm legit on there, and I don't have to worry about probate. I don't have to worry about the mortgages saying whatever, 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 because hey, I'm on title and I have rights on this property.
Right. Yeah. It's
I'm,
great
mute-
information.
I'm muted. Great information indeed. Great information indeed. So much. You've shared a lot. I have a question from one of our audience member, Miss Juanica, and she says, if an individual wanted to set up a trust, that what are some of the things they will need to put together to get started?
So if you want to set up a trust, you want to know, if this is for a property, of course, you want to have the property information, of course, a deed that has a legal description and the PIN and all of that. And then you want to, I like, I tell people just do an accounting of all of your stuff. What I have, property, okay. My, stuff that I have, if you have like some expensive designer bags or whatever, list them all. If you have bank accounts, list them all. If you have insurance, and insurance account, 401k, whatever, you list them all. So basically, some of those things you can address the estate planning with. Like for example, with the bank, you can just do that with the bank, on the bank paperwork, where you don't have to bring it into the trust. So main thing is just get like a whole full overview list of everything that you own. And from that point, you can now decide, okay, what do I need to? So things that have to be held in a trust. If it's something that is, um, that has a title, like a car, then okay, I need to transfer the title into the name of the trust. those kind of things with titles are transferred into a trust. Like the property is transferred into a trust. So things that have to be legally held in a certain entity, then you start moving them into a trust. And then, sometimes you can do a transfer of debt instrument on some things. But number one is just to get the whole picture of, okay, this is all my stuff. And then now you start outlining, okay, this is how I want them to be handled, and this is what I want my trustee. This is how I want my trustee to kind of like distribute these assets or use these assets for the benefit of the beneficiaries.
Awesome, awesome. It
That's a great.
is.
That's a great question too.
Yeah.
Yes, yes,
Yeah.
indeed. I had a follow-up question which I should have typed. I would have remembered it. But I was listening to your information. I think this is Mika. She says, "Great, great info."
You're welcome.
Uh,
Thank you for that question.
yes, very true. Well, thank you. Daphne, any question you have before we ask Attorney Grace? How can people connect with her?
No, no, no.
No.
Thank you.
Okay. So talk to us. How can people who wants to further maybe have a conversation with you? How
Um,
can they reach you?
you can call me. My number is up there, 312-619-0564. Email is also good. You can email me at info@ericlawgroup.com. I can put that in the, can I put it in the comments? No, I have to join the chat. So
Mm-hmm.
info@ericlawgroup.com, which is ERICLAW group.com. And then I think I see my handles are going on there. That's for Instagram, Facebook. Yeah, shoot me an email, leave me a message, and definitely assist you anywhere I can.
Thank you so much for being on the show.
Thank you for having me.
Back to you, Daphne.
Okay, so I was updating Attorney Grace contact information with the email
Yeah.
info at ericlawgroup.com. Okay, and then so I guess my last question would be like, what advice do you have for someone right now who may say, well, I don't have much, so why, I remember my question. How soon, once someone purchases a new property, how soon should they consider putting it in a trust?
I actually say immediately.
Immediately.
Immediately. So generally when, usually, if there's financing involved and we're closing, the lender is like, oh, I don't want it in a trust. But sometimes they will agree to that and for you to put it in a trust. But something you can also do is you can also quick claim it into the trust after the purchase. And of course, hey, that takes care of it. So I would definitely say as soon as you can do that, or if you can do that at closing, sometimes you can do it as you are closing, get that done. And if you can't do it as soon as you close, get that process started.
Awesome, awesome. So yes, last advice. Someone who's watching right now who may say, "Well, I don't have much. Why should I have a choice?" What final advice do you have for audience members right now?
If you have a property, you definitely need a trust. If you have a property, because I think, and that was what started this conversation again, is, as Daphne, not one, I'm going to call you Daphne, one, Daphne, two. As Daphne talked, like people are losing homes, we're losing wealth in our communities because we're not taking advantage of all these simple tools that are readily available. And we have this notion that, oh, it's only for rich people. Like, no, it's not,
Yeah.
because the probate courts, the rich people are not paying all the money and going through the probate court, like
Yeah.
we are, and we are the ones that need to keep our wealth and end up being the ones spending all this money in the probate
Mhm.
court when we could have just saved the whole family all of that headache, all of that stress. And I mean, I think even for someone for everyone, you're either doing it for yourself, you're doing it for your family, you're doing it for your peace of mind. So yeah.
I think Wanika's not trying to let you go this evening.
Like,
Wanika said, I have questions. Thank
yeah,
you so much for
you can,
engaging with us, Wanika. I appreciate you.
thank you, Juanita.
Uh, so that's gonna be the final question, and then we're gonna have to thank Miss Attorney Grace for her time this evening. She said, she said, I'm just going to call her.
Call me.
But we do appreciate the engagement. Can multiple, I'm thinking you say multiple properties go
Right.
Yeah,
into
can
trust?
multiple properties
Mm-hmm.
go into a trust? Yes, you can put the multiple properties in a trust.
Yeah. Um, So I guess like with Daphnee, attorney Daphnee Camilien and I, so we've had this series on real estate, right? So we started with starting an investment portfolio and growing it and scaling it, and then we moved to maybe like home ownership, right? But then when we having those conversation, we don't want to just educate people about how to gain wealth, through real estate. We also want to bring you information on how to protect the wealth,
Protect, yes,
because we don't want you to go and invest, buy properties, build generational wealth, and then lose it all for a measly 1,000 to 3,000, $5,000 even.
exactly.
From my personal experience, I used to be a banker. Um, we do not um, honor wills, not at all.
No,
Even if it's like a simple checking account, you bring a will, we do not honor it. We will tell you go to probate, and bring that to us, okay? And then so even when we're opening an account, I mean, I would always ask my client, do you want to add a beneficiary at the time of opening an account? And then I usually have some people who say no, you
yeah,
know but then when life happen, and then we tell you you have, and then the other thing is we're not able to tell you how much money is in the account.
we
So
can't.
we cannot tell you, and then so now you go to probate and find out
And it's funny you say that, and I
you
have to
too
say
much
because
money.
no, it's funny you say that because I definitely had a situation where the husband passed away, and just because you're the wife, it does not give you automatic, access to the person's to your husband's bank account. So the bank is like, hey, look, you need to follow all these steps before we can release it, because what happens is if they do release it to you,
Yeah.
somebody else can say, hey, I have
Hmm.
legal right to this, and so this woman was like, okay, I know he has an account here. And I'm like, okay, how much is in there? She doesn't know. Well, we got to spend money to find out. And now it's like, I don't know if it's 2 cents in there. What am I, like, and and it could be
It
$100,000
could be.
or something. And a lot of times is, yes, you don't want people to know your business, but I think, just to another thing, please. One of the takeaways everyone can take away from here, even myself, I got to go check my account. But
Check
we
back.
can all just go back to our bank accounts and check to make sure that we have updated beneficiaries,
Right.
listed on the account and things like that. Because a lot of times, and true story, had a guy, because there's immigration side too. Someone married someone. They were like, okay, found out that, there was the whole issue of, oh, you only married me for papers or whatever. Well, guess what? This person died. And this person that only married you for paper is the surviving spouse. So if you go to probate, they're gonna get all your stuff. So he's
Yeah.
rolling over like, oh my
Yeah.
God.
Yeah.
So
Just add the
Wow.
beneficiary. It's simple. When we're
yeah,
opening the account for you, you can just add it right then and there. It's at no cost to you. Please do it.
yeah.
Uh,
Banks
nope.
don't honor will.
Mm-mm. Nope. I think that's Mika. She said banks do not honor wills. Mm-mm. I was a banker. We do not honor will.
No, they can't because of fraud. They
Hmm.
can't. You
I
anybody can make a will.
I have the case with the property where we were selling was this person said, oh, this is my daddy's last will. We're filing it. This is his signature. Guess what? We checked online. Somebody had probated another
Mm-mm.
will with this man's name. Not only that, now having like different children, different for what's on this will. So the will has to be validated by the court before anyone will honor it. And that is what the probate process does.
Yeah, it's actually Laurie. Hey, Laurie. Thanks for joining us. Yeah, Laurie was our guest.
Last week.
Last week, talking to us about the 5 pitfalls when buying a house. And yeah, you can connect with her at haitianwealthy.com. Yep, banks do not. I
And
don't know.
Lord,
This was such a rich conversation. We went above and beyond. And I'm sure Attorney Grace just scratched the surface. So if you want to get more information, you want to have a consultation, please reach out to her either on Instagram, as you see the handle, her phone number, or her website, which is ericlawgroup.com. Her Instagram handle is at Okorie-Eric, period, law, or call 312-619-0564. Attorney Camilien mostly focus on immigration law, but obviously she can assist you however you need as well. So if you want to reach out to her, you can connect at 847-410-9022 or chameleonlaw.com. 847-410-9022 at chameleonlaw.com. And so what I do is basically help you with launching your business, resources to help you thrive as an entrepreneur. So if you want more information, you can connect at AntoineResources.com. It is AntoineResources.com, so you can get all the tools you need to have a profitable business. Miss Attorney Grace Okorie, thank you so much. We appreciate you. Don't leave, stay in the background as we say goodbye to our audience. Oh, I'm sorry. Let me add you.
Oh
I
no,
think you wanted to say something. No?
no, I was just saying thank you so much for having me, and thank you everyone for joining in.
Awesome. Well, thank you once again, everyone, for joining in. We so appreciate you all. We appreciate the engagement. I'm sure this is a conversation that you need to share with every person that you care about, whether that be a friend or a family member. Maybe that's your parent you need to send this conversation with. If they don't want to listen to what you have to say, I'm sure they want to listen to Attorney Camilien and Attorney Okorie. So please share this live, and do us a favor and take action. Because at the end of the day, we're not just here to talk. We do actually care about you, care about your finances, and care about your family. So go ahead and take action. And the one thing you can do is check to see if your accounts have beneficiaries. And then the next thing you need to do is connect with Attorney Grace Okorie to get your trust started. And anytime I say thank you. Anything else you wanna say?
No, just thank you. Great topic, great discussion, great feedback.
Awesome. Well, we will see you next week at 8 p.m. Central Time. Join the conversation. And if there's any topic that you want us to cover, or if you want us to bring guests to discuss a specific topic, feel free to reach out to us. We do have a Facebook page, which is the Daphnee and Daphnee Show, so that you can connect with us. Let us know what matters to you, and we will definitely get the resources to help you thrive. Bye for now. See you all next week. This was the
Bye.
Daphnee and Daphnee Show, and I'm Daphnee Antoine
I'm
with
Daphnee Camilien.
Daphnee
Bye.
Camilien. Bye for now.